Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the construction employee exemption as it pertains to the Alberta Employment Standards Regulations and how far too many individuals who have been fired or terminated from their job and believe that their employment is tied to the construction field feel that this particular exemption excludes them from receiving termination notice, or more importantly, termination pay in lieu of notice. And even where it does apply, and this is what we're also going to look into at the end of this video, is the aspect of when it does apply, it's only applying on the statutory level. But because people too quickly look at the statutory level, they fail to look at the common law level of wrongful dismissal and the requirements of notice and pay on account of notice in those circumstances. But let's start off by looking at the statute itself and what the regulation has to say, because the regulation is very tight and specific. And even though someone might consider themselves to be employed in the construction field, they do not necessarily have to meet the exemption that exists in the statute, because that's a very tight exemption in many respects to a certain frame of construction employees. So there's a lot of people who work in the construction field, like I say, who may think they are or be treated as if they are, and therefore walk away without no termination pay, no pay whatsoever, severance or otherwise, from when they're fired or terminated from their job, even though the statute and the regulation does not apply to them. So what we're looking at is Section 5.1 of the Alberta Employment Standards Regulation, which says no termination notice is required to be given by an employee, and no termination notice, termination pay, or a combination of termination notice and termination pay is required to be given or paid by an employer to terminate the employment of an employee if A, the employee is employed, hear these words, at the site of and in the construction, erection, repair, remodeling, alteration, painting, interior decoration, or demolition of any of these things: a building or structure, a road, highway, railway, or airfield, sidewalk, curb or gutter, pipeline, irrigation or drainage system, earth and rock filled dam, sewage system, power transmission line or power distribution system, or gas distribution system, unless the employee, 1, is employed to perform ongoing maintenance, or 2, is employed as an office employee. Now that is highly specific in that you must be both employed at the site and you have to be performing those specific tasks in the process of effectuating the construction. That doesn't exist, and it oftentimes doesn't in what I call construction support services or off-site construction related services. You're not following within the exemption, and as such the regulation doesn't apply on its face. So if you're producing stuff that is of construction nature, that is used in the construction field, or is not occurring on the site of the construction itself, it's very possible that this exemption does not apply to yourself. And even where the exemption does apply, you have to remember this pertains to the statute alone. It does not have the capacity to take away the common law court precedent with respect to wrongful dismissal, as I discussed in another video, from the case Cunningham versus Hillview Homes Ltd. From the Court of Queen's Bench of Alberta, and the judgment of Mr. Justice David Gates, where he found even though you have this exemption, it only pertains to the statute. And here's the other thing. Whether or not you are classified as a construction employee or not, if you're engaged in the construction field, let's say, and your former employer has terminated or fired yourself, and you've got nothing or next to nothing in the way of termination and severance pay from that employer, what do you have to lose to talk to a lawyer, to ascertain the true facts of your situation, to ascertain what in fact you might be legally entitled to, whether it's by way of statute and or common law? So when you're offered nothing or next to nothing, and you haven't had to sign a release to get that nothingness, well, in that circumstance, you have nothing further to lose other than to find out that you might be legally entitled to something, even under the Employment Standards Code, because the exemption might not pertain to yourself. As I say, even if it does, it doesn't mean you're entitled from wrongful dismissal and common law severance pay. So you really need to be taking a look at these aspects if you are in the construction field, and not simply saying, well, I'm going to classify myself because my employer says so, and other people say I'm a construction employee, when you might not be, because it's a very tight definition. Far too often, people right away jump to the conclusion that because they are in the construction field, they automatically are exempt. Whether it's they're exempt from statutory aspects, or they don't even consider the common law aspects. That's why you have lawyers, and that's why you should discuss with them the particulars of your situation. Because especially when you've received nothing or next to nothing, it doesn't hurt to investigate further. Thank you.